Good evening, everyone. Welcome to our Soft and Life Skills series, Basic Myths and Facts of Immigration. With Nadine Atkinson Flowers. She's an attorney at law and she'll be our presenter tonight. Now, I just want to confirm that you're all hearing me. Can you type in the chat or use your reactions for a thumbs up or something just to confirm, please? Okay, great. So I'm seeing persons confirming that they're actually hearing me. As I said earlier, welcome to our Soft and Life Skills series, Basic Myths and Facts about U.S. Immigration with Nadine Atkinson Flowers, an attorney at law and UA alumna. This evening, our session will be recorded as we got permission from our presenter, so the audience may appear in the recorded sessions. Also, this is a voice-activated call, so if your mic is unmuted and you speak or there's some feedback, it will interrupt the presenter. So we're asking you to keep your mics muted until the Q&A session. Now, our presenter will go ahead and introduce herself, and then after her presentation, we'll jump into the Q&A. Looking forward to a good presentation.
Thank you. Good evening, everybody. I am very happy that you've joined us, and I hope that at the end of the session, you will come away informed, and hopefully I would have been able to share some tips and suggestions with you as it concerns the facts and myths about US immigration. Now, you're free to type questions in the chat if you wish, or if you feel that it's a burning question, you can't wait, you can always unmute and ask, because we would want to hear from you and want everybody to get the opportunity to share in this evening. So I thank you again for joining us, and let's begin. Now, the whole issue of US immigration continues to be a hot button topic, as we might say in Jamaica, not only because of the fact that everybody seems to have been gripped by events in the United States in the past few months, the US elections that took place in November 2020, and all of the other drama that seemed to occur every time you close your eyes and open them again. Something more dramatic is happening in the States, and immigration in the US is unfortunately one of those areas. A lot of persons in Jamaica obviously have American connections. We have persons, perhaps some persons would like to say half of Jamaica probably live in the United States, and they like to say that if America catches a cold, it is Kingston that sneezes. So I want to take us briefly through the visa categories that exist for American immigration. Then I will look at common myths and facts. I'll spend a little time talking about scams online that always exist. And then I will look at a few specific programs that are only accessible to particular countries, and perhaps sometimes are only accessible to persons in the United States itself. So I take you now to the popular visa categories. I think everybody knows about family-based immigration, meaning your parents or your sibling or your spouse or your child is what we call filing for you. That is called really family-based immigration. It is one of the immigrant visa categories. And when I say immigrant visa categories, I mean that your intention by getting this visa is to go to the United States, to live there permanently. And that is distinct from what is called the non-immigrant visa. That is the visa that we get when we are just traveling to the United States for a vacation, or we're going to attend school, such as, you might be going to university, or you might be doing your graduate studies at a university in the United States. And there are also employment-based work permits. So for example, if you were a musician and you wanted to go and do a number of shows in the US, you would get a work permit, but it is actually a non-immigrant visa. So there are then two distinct categories of visas for the United States. There's the immigrant visa category and there's the non-immigrant visa category. There is a segment called asylum as well. Asylum is an interesting category because that relates to persons who have actually entered into the United States. And when they get to the United States, they say to the Custom and Border Patrol agents, we call in Jamaica, we call them the immigration officers. You say, well, you know, in my country of origin, my political opinions, I am facing a significant amount of pressure for them. They are torturing me because of my political opinions, or torturing me, or want to torture me because of my religious beliefs, or because of my sexual preferences. Those persons can seek what is called asylum in the United States. Then there are persons who are living in war-torn countries, or countries where they are discriminated against because of race, religion, ethnicity. They, from their countries or neighboring countries, can seek to become a refugee in the United States. The student visa is an interesting category because it is a non-immigrant visa category. So that means when you get that visa, you will always, well, you're always expected, I should say, to return home after your studies are finished. We have heard of many of our students, such as athletes, who go to the United States and they do higher education, whether they're going to be doing their bachelor's, or some persons may be doing master's degrees, other types of studies. Those persons would get what is called a student visa. But at the end of the period of study, it is expected that you are going to be returning home. Now, I'll jump right into the myths, but before I do that, I'm reminded of something that always happens when I see, for example, new clients, whether they're Jamaican clients with criminal matter issues, or they're US clients who may wish to be doing an immigration case. They always say, well, you know, my friend do the same thing and him get through, or my friend do it and everything all right, or my friend do it and him get through in 3 months. I say that to say that a lot of persons are of the view that because someone else's case appears similar to theirs, then the result is going to be the same. And that is not necessarily so, because as we all know, what for me is not necessarily for you. And as such, I always caution persons and say to them, yes, he might have got a positive result, but you don't know the specifics of that person's case. It is the specifics of any case that is going to determine your outcome. So never ever figure, oh, my friend do it, him get through, me must do it, and me must get through too. Doesn't usually work like that. So let's look at myth number 1. People tend to feel that, well, if I have a multiple entry visa and I go to the United States, I cannot overstay. That is incorrect. The fact of the matter is, whether you're getting a, let's say, a 1-year multiple entry, meaning you can go to the United States as many times as you wish in the year, or a 5-year multiple entry, or even a 10-year multiple entry visa, that is not really the decisive factor. The decisive and deciding factor is what happens when you land in the United States. When you meet, pardon me, that immigration officer for the first time, and he says to you, so you're from the land of ackee and saltfish, and you boldly and very proudly say, yes. And I am here to spend 3 months or 2 months, pardon me, with friends and family or whatever it is. And they stamp in your passport how long you are expected to remain in the United States. So for example, let's say you had your 10-year multiple entry visa and you came to the United States, told them that you're here for a wedding. Afterwards, you're going to do some sightseeing. You expect to be home within the month. And they stamp in your passport 2 weeks. You go and you have yourself a good time and you're here for the full month because that's what you told them. You didn't expect that they were going to actually put 2 weeks in your passport. You have actually overstayed, as they say, your visa and the time that you were allowed to be in the country. For those times, often maybe you will not have an issue. The issue comes, for example, if you got a chance to stay for, let's say you said you were going to stay a week and they gave you 4 months. Said, oh, wonderful. And you stay for 2 years. Now you have definitely overstayed your visa. And it is quite likely that when you return to the United States, you may well be denied entry. So it's extremely important to look in your passport to see exactly how much time they've given you. We have another myth that a lot of persons tend to talk about. They tend to say that you don't need anybody to file for you to come and live in the United States permanently if you have a visitor's visa. As I told you at the beginning, there are 2 main categories of visas. There are the immigrant visas and there are the non-immigrant visas. This particular myth, the fact of the matter is that there must be what we call a path to an immigration benefit in the United States. And as such, there are only a few specific ways in which you can be petitioned for. That is the fancy term that they use. You can be petitioned for to come to live permanently in the United States, such as your parents, your spouse, or a sibling who is going to complete those documents for you. Now, just recently, someone actually asked me if that person could join the armed forces and become a US citizen without one of these benefits in the first place. That would not be possible. But I thought it was an interesting question in light of the presentation that I was preparing for this evening. So the question I asked the person is, do you have someone in the United States who is going to be petitioning for you or filing for you? And the answer was no. So one has to be very cautious about that. Now, another myth that persons tend to have is that if you get deadlines from the US immigration authorities, you can miss it by a day or 2 because that's not a big deal. But the fact of the matter is that if they sent you a letter or any other document to say, we would like information about 1, 2, 3 issues, and we would like it within X number of days, they expect that you're going to fulfill that deadline either on that day or before that day, because they are working with very strict time constraints. And they have actually considered how many days it will take or it should take someone to complete this task that we've asked. So let's say, for example, you've been asked to provide a police report within 87 days. That's a good number that they always like to choose. And you submit it the 89th day because you're thinking it's just 2 days. You may well have an issue. So it's always very important to ensure that you follow any deadlines that you're given. Another myth that a lot of persons seem to have is that anybody can file for someone in the home country. Now, of course, that is not so. In the land of US immigration, there are 2 persons. There is a US citizen and there is a legal permanent resident. A US citizen is either someone who was born in the country or who naturalized, meaning they were a resident and they became a citizen after a period of time. The US citizen can petition for a parent, a spouse, a sibling, a child. The legal permanent resident does not have all of those at his disposal. A legal permanent resident can only petition for, pardon me, a spouse and or children. So that's very important to recognize, because oftentimes persons begin to put things in place and sell their property, which you're always advised never to do when you're doing the immigration process, because they assume that they are going to be moving to the United States sooner than later. And then they find that they have a roadblock. So you have to be very careful about that. Another thing that persons seem not to recognize is that criminal issues in one country, people feel that they don't have to disclose on US immigration forms. No, the fact is really that almost every US visa application form, whether it's for a non-immigrant visa or an immigrant visa meaning you're coming to live, asks you about criminal law issues. The questions might be as simple as, have you ever been arrested? But then you'll get the more complex ones. Have you ever been convicted? Have you ever been charged? Or have you ever had a disposition, meaning have you ever been to court and something came out of it at the end and you might have had to pay a fine, what we call in Jamaica a road sentence. In the criminal law, that's what we call it. If you did something and you end up not going to prison or to jail, we say you get a road sentence. But a road sentence is still a sentence. And as such, you're expected to indicate it. And also, it is important to recognize that you will be asked for a police clearance certificate. At home in Jamaica, we call that our police record. When you go to get the police record, once you have had some interaction with the criminal law system and your fingerprints were taken, your name is going to come up in the system of the Jamaica Constabulary Force, and they will be able to issue a police clearance certificate that has information about any interaction you had with the criminal justice system at home when you were in Jamaica, if you're now overseas or if you're still in Jamaica. So it is very important to remember these things. And strangely enough, persons sometimes tend to forget, oh, but that time when me I did 20 and me are 50 now, doesn't matter. You need to recognize that these things are important, and the law, unfortunately or fortunately, has a very long memory. So you have to be careful when you are doing those forms, because at the end of the day, the onus is on you. You can't say, oh, but the travel agency pulled it out for me, I think she did ask me. Oh, but the liar, and she never asked me that question there. You have to remember. Now, I've heard a lot of persons with this one that you can petition for relatives like your cousins, your aunts, your grandparents. The fact that in Jamaica, we are a nation of an extended family. So we live with all of our relatives and we think all of them are our immediate family. Not so for US immigration. You can only petition for parents, as I said before, spouses, children, and siblings. So unfortunately, the cousin who grew up with you from you were both 2 and now you're 50 or whatever age, and you are living in the US and you see her as your sister and you want to petition for her, unfortunately, you won't be able to do that. Another myth that a lot of persons seem to be laboring under is the whole business of whether you came to the US as what we say a work permit or a visitor or a student visa and your visa overstay. They tend to think you can just become a resident. There is almost like there's some forms that you fill out to change from being a visitor or a student or coming on a work permit. There is no such thing. In fact, as I said before, you have to have some kind of path. So whether it is that you have a parent who is going to be petitioning for you, or you have fallen madly in love with someone here, and that person is going to marry you, and then they will put the petition in for you. Or, for example, if you have a sibling here who is a citizen, and that sibling can put documents in for you. But there again, there are going to be some issues because you may well be required to go back to your home country to complete the process. And that's what a lot of persons sometimes do not understand, that whilst the paths are there, some of them are fraught with various issues, and you have to be cognizant of those. Now, a lot of persons have this view that if you are a legal permanent resident, you can never lose that status. In the vernacular, they call it the LPR. That, of course, is not so because, and certainly COVID has shown us this, where a lot of persons were stuck in various countries and could not return to their own countries, or if they were residents, they could not return to the United States. The law says that if you actually remain outside of the United States as a resident for the period of 1 year, it is assumed in the law that you have abandoned your status as a legal permanent resident. That's the word that the law uses. You have abandoned your status. And you will have to show extenuating circumstances as to why you had to remain outside of the United States for an entire year. Extenuating circumstances could be, for example, you're suffering from a grave illness and you were doing certain types of treatments that prevented you from traveling. Or you had a relative who was extremely ill and that relative had no one else to take care of him or her. And it fell to you, despite the fact that you were a legal permanent resident of the United States, it fell to you to take care of that relative. And so you had to stay. It's almost those kind of life-death situations that you have to present as an extenuating circumstance should you remain outside of the States for the period of a year or more. Another myth that a lot of persons tend to have is that as a resident, you don't have to file taxes if you're not living in the United States. No, everybody knows that the taxman is always there. If it is that you are a resident and you're outside of the US for a period, it is extremely useful that you speak with, whether it's a chartered public accountant or a certified public accountant, so that he or she can advise you on any tax liability that you may have by virtue of the fact that you're outside of the States. And certainly, if it is that you come back to the States and you wish, for example, to petition for a relative, the taxman is going to ask you the question, so when was the last time you filed taxes? You're going to have to put that on the document that you are submitting. And so you will need to be able to sort that out. Now, persons tend to think too that if you were adopted and you came to the United States as a resident and or became a citizen later on, you can then turn around and petition for your biological parent. That is not so. And that is a common question that a lot of persons ask. Adoption terminates the rights of a biological parent. No two ways about it. The law is very clear about that. If you have been adopted by someone, that person now becomes your parent, and your biological parents, that legal relationship with them is now severed forever. And as such, those biological children, will never be able to petition for you to come to the United States. There is nothing to say that these adopted children can't continue to have a relationship with their biological parents. However, in the law, they are not allowed to petition for their biological parents or their biological siblings. No, this is actually a very common one. persons tend to feel that, for example, if you didn't serve time in jail or in prison, I alluded to that earlier, for a criminal offense in the United States, you can't be deported to your home country. That is not so. And increasingly, we're finding that persons who have negative interactions with the justice system find themselves being deported, sometimes to a country that they have not seen for many years, sometimes to a country that they perhaps left when they were children, 4, 5, 6, 7, and they find that they are being deported to these countries. So it is very important to recognize that if you have an issue with the criminal justice system, guilt or innocence aside, it is crucial that you speak to not just your criminal lawyer about what steps can be taken, but also to get hold of an immigration lawyer as well, because the criminal lawyer may not know that you may be deported. Criminal lawyer may not even care. But the fact of the matter is, you have to recognize this. And too few people take the steps of being very robust about their own defense and advocating for themselves. They're told, this is what we're going to do. And they don't say, no, but my status is so and so and so. If I do that, won't I be deported? So that, as we used to say in Jamaica, put the pop in their mouth, put the pop in the lawyer mouth, let the lawyer say, you know, I'm not sure. Let me go and check it out. But if you just sit there and say, all right, anything what you say, sir, you may well find yourself on a plane heading to wherever it is you're from, Jamaica or another Caribbean island or whatever. So it is crucial, I like to tell people, you have to advocate for yourself in these circumstances, especially in a country where there are so many things moving at such a pace, and there's so many things that affect everything. Race, the fact that you might speak patois and they don't understand, or they say they don't understand, the fact that their culture is different. All of those things are important. So it's very crucial that you ensure that you're advocating for yourself if you should, God forbid, find yourself before the criminal courts. Now, another myth that persons have is, and this really applies to persons who are married and they are in the States, sometimes they are in their home countries. Oh, I'm married real man, I'm not prepared for no interview. No. Fact of the matter is that you have to convince the immigration officer that your marriage is in fact real. You have to remember your spouse's date of birth. You have to remember where you met. You have to remember how he or she proposed. You have to remember how many children he has or she has before you got together, parents' name, all of those things. And it's not really an issue that you may not have a real marriage, because even in real marriages, people tend to forget. Some husbands don't remember their wife's birthday or the anniversary or even the children's birthday. And this is a stressful situation, because if the officer is not convinced of the good faith marriage, that's what they call it, they're not convinced of a good faith marriage, they may well deny you. And so you're going to now find yourself trying to convince them. And so it's a high stress situation, and persons tend not to take it seriously. So the interview may well be, if you're in the States, it's going to be at one of the USCIS offices, that's United States Citizenship and Immigration Services offices. If it's in your home country, such as in Jamaica, you are going to be going to the embassy. And for anybody who's gone to the embassy in Jamaica, you know that that can be quite a stressful situation. So imagine somebody asking you these questions all the time, thinking in the back of their heads, this thing is not real. So you have to be careful where that is concerned. Now, a lot of persons tend to feel that if you're a citizen by naturalization, it can't be revoked. That's not true, and that's very important for people to recognize, because no, more than ever, I don't know if it will continue to happen, but they are taking a very keen interest in persons who may have told, let's say, lies in the past, and they want to say that particular lie that you told, you grossly misrepresented. And having misrepresented, you don't have what we call good moral character. And since you don't have this good moral character, you, sir, or you, ma'am, cannot be a US citizen. And we are going to strip you of that citizenship. So you have to be very careful. There is now something that the new government is doing. It's called the Biden plan, whereby the government is trying to get a bill passed that will positively affect persons who've been in the States for some time without lawful or legal status. And persons are very excited about this, but caution must prevail because it is still yet a bill. It has not gone anywhere as yet. They're still thinking about how it will look. And at the end of the day, it may well look very different from how it looks now. So this is one of the areas where sometimes scams tend to arise, because people will be telling you, oh, you can pay me and I'll ensure that all your paperwork is submitted to get into this Biden plan, to get into this new immigration law that the government is coming with. But I'm here to caution you and to tell you that as it stands now, there is nothing that has been finalized, as we say in Jamaica, no pen no put to paper. So you have to be very careful so that you are not scammed out of your hard-earned money. Persons don't realize, and this is another myth, that you have to show certain, call it civil documents. What are civil documents? Your birth certificate, your marriage certificate, and crucially, divorce decrees. In Jamaica, for example, the divorce is a two-step process. You get what is called, excuse me, the decree nisi after 6 weeks. You apply for your decree absolute. Without your decree absolute, you're not divorced. So many persons have fallen into this trap where they meet someone new, they're establishing a new relationship, they complete their forms to become residents in the United States, and they're asked to provide evidence of the divorce. And all they have is the decree nisi. And when they submit those documents and they're advised by the US authorities that they're not divorced, they're like, oh, you mean a divorce? Simply mean you did not complete the process. And that kind of holds true for a number of jurisdictions. So you have to make sure that you are totally severed from the first marriage in order to initiate a second one. Oh, I think we did this one already. So let's go down. Oh, you've been hearing me speak for some time now about the whole issue of the marriage-based visa or the marriage-based green card, which means that your husband or your wife puts in the petition on your behalf for you to become a legal permanent resident in the United States. So let's say that that happy process has taken place. You're married, you're living happily, your husband or your wife has put the, pardon me, has put the paperwork in for you, the petition for you to become a resident. You get that green card, you come back to Jamaica or your other country to look for your friends and family, and the marriage is now in its second year. But God forbid, the marriage goes downhill for whatever reason, and you decide, well, I can't take it no more. And you decide you are going to get a divorce. Pause. In getting that divorce, a number of things are happening. The marriage-based visa, you get that visa for 2 years initially. At the end of the 2 years, you are expected to return to the government with additional paperwork to show that your marriage is still alive and well. Your good faith marriage is still subsisting. Yourself and your spouse have never been happier, and so on and so forth. But the law recognizes that life happens. And so the law says, if it is that the marriage has gone downhill and you have got a divorce, you can still get your 5-year green card, your 5-year residency, but you have to show us that the marriage was real in the first place. A lot of persons tend simply to just get their divorce and waive that before the US immigration authorities. That alone, ladies and gentlemen in the audience, will not fly. You are going to be asked to show that from the get-go, the marriage was a good faith marriage. So you will have to present your evidence, such as when you lived together, you had a house, you leased or rented property here, or you had bank accounts together, you bought furniture together, you took trips, you had children. All of those things will be required. And this, unfortunately, is something that happens to a lot of persons. So I caution you to be very, very careful. And in keeping with what I was saying about the fact that Jamaicans, especially, and Caribbean people, we tend to live in our extended families. There's another myth that persons have where they feel that if you have a child that you never formally adopted, you can actually petition for that child. That is not so. The fact of the matter is, only a child that you formally adopted can be petitioned for. And so imagine how terrible it would be if you were not aware of this and this child has been living with you and the child is now 15 years and 11 months. It's almost too late to start the process, because in Jamaica, excuse me, for example, an adoption can't take place after the 16th birthday. But had you recognized this years before, you could have started the process. So this is very important for persons to recognize, because it can cause so much emotional trauma to persons, as it really is going to mean the breakup of a family. And at the very least, persons will be living in country A and other persons will be living in country B, unable to visit and to maintain their family relationships. Now, I want to talk just a little bit about US visa scams. As I prepared for this presentation, I actually saw online, and the link is there, where the United States mission in Nigeria was drawing the public's attention to a fake press release that claimed that the US was offering new types of work visas. Of course, the embassy is essentially saying that this is a scam, don't be a victim, and whether if we are going to be issuing visas, we would do it through official sources. And they indicate some of the official sources, such as the state government, and USCIS is also a legitimate source of information about US immigration. Unfortunately, visa scams are a dime a dozen, because persons want to go to the United States to make better lives for themselves, to work so their children can go to school, to attend school themselves. And so you may find that persons become a little desperate, I'm going to say, and may not be as thoughtful about what they're doing as they perhaps usually would. So, for example, if somebody asks you to pay them lots of money and to get you a US visa, that should be a red flag, especially if it's somebody that you don't know. And if they're actually promising you that you will get the visa, that has to be a red flag. Because they can't make that promise. When you stand before that visa officer at the consulate, or if you're already in the States at the immigration office, it is that officer who makes the decision. So everything that has been done before can only put you in a good position, a good place to get the visa benefit, but there's no guarantee. So that in and of itself should be a red flag. Another big red flag is that persons appear caged, them shifty when you say, explain to me the steps that you're going to take on my behalf, or how long do you anticipate that you're going to take to complete my paperwork, or where is my receipt? That's a very important question. You're doling over thousands of dollars to persons and you're not getting a receipt. It's absolutely crucial that you recognize that these are flags. Another scam that other persons tend to fall for is a work visa scam. So they tell you, oh, fill out all these paperwork, bring in all these documents, we are going to take them to the embassy. You will always have to appear at the embassy, 99% of the cases. So if somebody is telling you, oh, we can fill out all of these paperwork for you, and then we can take it to the embassy, flag, run them, as we would say. I'm going to leave you with that last slide of visa scams and how to identify them. I don't know if anybody has any questions, but I am happy to answer them if I can.
Hi, Nadine. That was such a, wealth of information that you shared. And before we get into question and answers, I just want to find out if this is a myth or a fact. I know persons are of the opinion that if you have a family member that's filing or petitioning on your behalf and you have a visitor visa, that you can just go and stay in the US until the process is complete. Is that fact or myth?
That it depends on who you are. Let's say, for example, you are the spouse. People do it. However, this is a caveat. When you go to that visa interview, they're going to say, you did not have good intentions when you got that visitor's visa, because your sole plan was to come to the United States and remain and do your processing there. So they're going to say yours is bad character and not good character. And of course, you're taking a significant risk, because if something happens to a family member in your home country, you may feel, oh Lord, I want to go to my grandmother's funeral, but I can't leave. So people have to be very, very cautious about that. I've heard people talk about it. I've had clients ask about it, and that's how I answer that question. You are better served, work a yard and wait for your process. Wait in the line that is there for you.
Okay, great. Thank you for that. All right, I'm seeing the chat here where Stacy Headley asks, will the change of marital status affect an individual's petition?
Yes, it does. There are several categories. So if you are under 21, you are called an unmarried child. When you become 21, you are no longer a child. You are called a son or a daughter. If you get married, you go into the third category, and you are now going to be called a married son or daughter. The average time now for a married son or daughter who has been petitioned for is probably about 10 years. So that's 10 years from when your parents filed the petition to the day when you are stepping on the plane with your little yellow package that they give you to hand to the immigration officers.
Okay, Stacey, I hope that answered your question. I'm seeing here a question from Hartho, asking if there's any information on sponsor work permit.
Well, I didn't focus much on that this evening, but yes, there are work permits that are available, and there are categories for that. Broadly speaking, for example, you could come on what we call in Jamaica the farm work program, whereby those persons go to various states to work on farms, whether it's picking fruits or vegetables, that kind of thing. There are other kind of work permits, such as, I think I mentioned this one earlier, excuse me, that certain types of artists get. So let's say I'm a singer and I'm coming to perform, I can get a work permit for that, or I'm a drummer, or I'm involved in dub poetry or whatever. There are work permits that can be obtained for that. I'm aware of programs that a lot of the universities have as well, where students go to, for example, hotels, and they work for the summers, hotel and tourist management students, that kind of thing. So there are a number of work permits that are available to persons to go to the US and work.
All right. I see another question here from Amanda. She's asking, if I've applied for a job in the USA that is offering visa sponsorship, what steps should I take to ensure that this includes my spouse and children?
It depends on the type of job. So there are certain categories that will offer you the sponsorship. Let's say, for example, you are a lecturer at a university, or you are a scientist, or whatever it is. There is a category for you, and there's also a subcategory for your spouse and your children. It depends entirely on the type of visa that you're being offered. And then you will have to ask your employers if that other category is going to be made available for your spouse and children. And you also have to think about whether your spouse will be able to work when he or she comes to the States, because not all of these work permit categories allow the spouse to work. So let's say, for example, you're a scientist and your spouse is an attorney. There is no rule for attorneys to just come to work in the United States like that. They have to be admitted to the bar in the United States. So those are little nitty-gritty questions that you have to sort out if you are getting sponsored for a job opportunity in the States.
Okay, guys, just a reminder, you can raise your hand to open your mic if you'd like to speak your question instead of typing. But before we get into that, I'm seeing another question here from Stacy Headley again. She's asking, can someone apply for a non-immigrant visa, B1 or B2, if the petition has not reached their home country?
I'm not quite sure I understand that. Does she mean?
Stacey, would you like to open
I'm
your
not
mic?
sure. I'm not sure I understand.
All right, I'm not hearing from Stacey.
Hi, good night.
Hi, how are you?
Hi. What I meant to say is, like, you know, when you petition in the United States, the documents have to go to come to your home country to be filled out, right, by immigration here. So if it hasn't reached your home country and you haven't completed those set of documents before you return it to the United States, will that affect if someone wants to apply for a B1, B2 non-immigrant visa?
Excuse me. Oh, I think I understand what you're saying.
Okay.
Now, the minute your petition gets filed, you're in the system. So they know. And so let's say whomever put your petition in on day one, but the documents have not yet come to you, if I understand what you're saying, for you to file. So you think that your home country is unaware of them? They're aware. They're waiting for you to tell them, well, you know, my mom is filing for me or my dad is petitioning for me, but I still just want to go and look for them. You know, I still want the visitor's visa. They are already aware. And I thank you very much for that question, because a lot of persons are of the view that in the government, the United States government, the left hand don't know what the right hand doing. No, that's not how it goes. They type your information in the system, and at the press of a button, they can say, oh, I see here that your mother is petitioning for you. So please be very cautious where that is concerned. there is nothing in the law that says you cannot get a B1, B2 visitor's visa whilst your immigration documents is being done for you to go and live in the States. What the law does say is that you're not to lie about it, because that will have very adverse consequences. And I've known lots of persons who are being petitioned for, and whilst they're being petitioned for, they're traveling back and forth because they have their visitor's visa. So it is quite possible, but as I said, the crucial thing is, don't think you can pull a fast one on them, because it usually doesn't work, and it's not necessary.
All right.
Okay,
All right. I'm going to take a question from Tiffany, and then I go to Christine, who has her hand raised. Tiffany asks, should the person petitioned for on a K1 decide not to get married, how will the person be implicated should a parent decide to file in the future?
Ooh, that's an interesting one. I've not given much thought to that. The K1 is a fiance visa. I know that for the K1 visa, you have to get married within, I think it's 90 days, but I've never really given much thought to the other part. I think a good rule of thumb would be just to be honest. So you came here, you didn't really like how him snore, or you didn't like how she snore, or whatever it was, and you decide, I married him again, and go back home. And later on, your parent or a sibling or a child is petitioning for you. There is actually a part on the petition that says, has anybody ever in the past petitioned for you? Your answer to that question in these circumstances should be yes.
All right, thank you. Christine, you can open your mic and ask your question.
Good afternoon. I was just wondering if income is important for the person who is filing a petition and somebody else.
I'm sorry, if income is important for?
The person who is filing the petition, if they have to have a certain income, or they have to be employed, or if they're retired, can they still file on behalf of another person?
The law requires that the petitioner, that's the main person, puts in what they call an affidavit of support to say, yes, I can support John Brown, or yes, I can support Nadine should the government grant her the immigrant visa. It is useful for that person to be working because they have something that's called the poverty guideline, and the poverty guidelines tell you that if you are supporting 2 persons, they expect you're earning X sum of money. If you're supporting 3 persons, you're expected to earn Y sum of money. If, for example, you don't have an income per se, but you have assets, say you own lots of houses somewhere, and therefore you get rent from those houses, that actually becomes your income. So you can use that to say, well, I can support this person when you give them the visa. So the long and short of it is that, yes, the petitioner must be able to show that he or she has some kind of income to support this person when he or she comes. If his income is not enough, he can get what is called a co-sponsor. And that co-sponsor is basically saying, I am agreeing that when John Brown or Tom Stroke comes to the United States, I will be able to support him or her as well. And that's a legal obligation. You have to sign a contract basically with the government.
So it doesn't matter if that person has retired or not?
No, but as I said, if you are retired, that means your income is going to fall, and therefore you have to have other types of assets.
Okay. Thank you.
You're welcome.
All right, Adrian, you can go ahead with your question.
Night, everyone.
Good evening.
My question is, I want to know what's the process of sponsoring myself. I would have had 3 actual exams, and I would like to pursue the profession in the States. So I wanted to know, is it possible for me to sponsor myself?
Let me see if I understand what you mean when you say sponsor yourself. When you say sponsor yourself, you mean you would put your documents in by yourself? Is that how I'm to understand it?
I'm not sure
without
that.
somebody, because all right, let me explain it this way. The United States has some very clear pathways to residency and then citizenship. Sponsoring yourself isn't truly one of them. What they do have are certain visas that are called extraordinary visas. So for example, you are the best actuary in the entire world. You are the sought after actuary. You have renowned qualification. You have worked in 100 countries and you have accolades longer than my two arms put together. In your particular case, you would be considered an extraordinary person, and you could put certain documents in for the visa that they have to say, well, there's nobody better than me in this area, and so I should get this particular visa, and that can eventually lead you to becoming a resident of the United States. But normal Nadine Atkinson Flowers, who's just a lawyer, the Americans don't care. So I would not be able to petition for myself. I would have to utilize one of the routes that are available, whether it's through a parent, a sibling, a spouse, or parent, relative, parent, spouse, sibling, children. Those would be the four that you would have to utilize. In your case, you could consider the issue of getting a student visa to pursue graduate work, at one of those universities, that kind of thing.
All right, thank you. I'd have to look into that last one then.
Yes, absolutely.
All right, Chantal, you can go ahead.
Okay, hello, good night.
Hi, how are you?
Good, good presentation thus far. The question I have is, how long after being issued a green card from an approved family-based petition can I get married and petition for my spouse?
All right, so let me make sure I understand. So you are unmarried?
Yes,
correct?
yes.
And you have got your green card, correct?
Well, I'm currently in the process.
If you marry, you fall into the other category.
Mm-hmm.
So you can, I won't say you cannot. If you wish to remain in this category of an unmarried son or daughter, then marriage can't happen now. If you don't have a problem with moving into the category of married son or daughter, go right ahead. So when people say you can't get married because you are waiting for your green card, no such thing, because the law doesn't say you cannot. What the law says is if you do, you move into the next category, because currently such a person would be in they call it the F2 category, I believe. You are the unmarried son or daughter of a United States citizen. But if you should marry, you become the married son or daughter of a United States citizen, and you fall into a further category down the line, and it will take longer for you to get your green card. And by the way, don't think that you can get around them by not telling them that you got married, because sooner or later it's going to come out. And again, they're going to draw the card on you and say, oh, you have bad character. You got married and you did not say.
So, all right, the question I have then, so at what point do I get married? When
you can get married? But you're not listening to me. You can get married anytime you want,
right,
but it puts you into a different category if you do.
All right, so let's say I wait until I'm granted this green card. As I'm granted it and I have it in my hand, can I go and get married?
You're trying to put me in trouble now. I will still answer you the way I did. If you have it in your hand, nobody can tell you what to do. But as I say, nobody can tell you what to do either way. You just have to be aware of the ramifications of path A and path B. Right?
Okay. Okay. All right. Thanks.
All right, Jerome, it's you. You're up next, but I think I want to get some clarification on what Chantel, asked. What she was saying is that if, for example, she gets the green card today and she decides to get married in another 3 months, how long after that can she start petitioning for the person who she got married to?
Oh, if you get married today at the Registrar General's office in Spanish Town, you can go straight home, go start fill out the paperwork. There's no time frame. There's no time frame to do it.
Okay then. Thanks for that clarification.
All right. Go ahead, Jerome, and then it's next to Paulette.
Okay, hi, good night. Thanks a lot, Ms. Atkinson Flowers, for all the information provided thus far.
Oh, you're welcome.
All right. My question is from the perspective of a professional who's seeking employment in the United States. So I know that there would have been some changes to the regulations with the last US administration. And so let's say I'm a professional, I'm looking for employment, and it's not in the tech sector. And I see a job that I want to apply for. How do I go about getting a work permit to work in this sector? Do I apply for the job and then ask for the company to sponsor me? And then there's a two-part question in terms of, is there a possibility to transition from a work permit to a legal permanent resident?
Yes, I'll answer the second one first. If you have certain types of work permits, employer-based work permits, it is quite possible to transition, I would say, to a legal permanent resident position, but it takes a little while. It does take a little while, and it's kind of stressful to those persons who have to experience it, because the work permit is like let's say it's for a year. And at the end of the year, you have to worry, is the employer going to renew it? And yes, they renew it, but whilst they're doing the whole renewal process, you have to wait outside the country. So some people go to Canada and wait, or some people fly to Mexico and wait a week or two for the paperwork to be approved. So yes, you can transition after having had an employer-based work permit. The first part of the question, no, as to whether or not you can apply for the job and then get a work permit. What usually happens is that if an employer wishes certain categories of workers to come to work with them in the United States, they have to be able to prove to the government that these persons have such great skills and such unique skills that they are not to be found in the United States at all, because obviously they want to protect the labor force here in the United States. So if you have found a particular position and you have applied for it, you can approach the employer to apply for a work permit for you, but it is quite an uphill battle, because that employer will now have to prove to the US government by use of what they call the labor certification and putting ads in the paper to say, one, nobody wants this job, or two, this job is so specific and this job requires such unique skills that only Nadine Flowers has those skills. And that is why we want her to get a work permit to come to the United States. And in fact, because it is such an uphill battle, a lot of jobs will actually say, we do not sponsor work permits. You have to already have got permission, or you already have to be in the country. So it is not an entirely easy process. I think I mentioned earlier that there are certain areas that it's kind of easy to get a work permit for, but other categories, you have to submit the different paperwork, and a lot of them actually have time frames during which you have to submit that paperwork. And if you don't submit it during that particular time frame, you may well find yourself out of pocket because you won't get the application processed and approved.
Okay, I hope that answered your question, Jerome. We're moving on to Paulette. You can go ahead and ask your question.
Thank you so much. Good evening to everybody.
Good evening.
Thanks so much, Ms. Flowers, for that presentation. Is there a maximum age for a parent who is being petitioned by a son or daughter? Suppose you are 70 years old, can you still get your son or daughter to petition for you?
You heard 70 is the new 50. Did you hear? Yes, man. No. There's no maximum age. And in fact, a lot of times, children will tend to want to petition for their parents who are fairly, ageable, because they want to take care of them, or they feel they can get them the health care that they're needed, and so on. So there is absolutely no maximum age. The problem lies in how long it will take.
It's longer for children to
look at it like this. There is a line.
Okay.
And for every line, you have to wait for your visa category, and you have to wait for your number to be called, literally. I haven't checked it recently, but I'm going to say petitioning for a spouse who's not living in the country where you are, let's say a year and a half. Petitioning for a child under 21, let's say 2 years. Petitioning for a sibling, let's say 10 years. Petitioning for a child, a married son or daughter, maybe 10 to 12 years. Petitioning for a parent, regardless of the age of the parent, you're maybe looking at maybe 6 to 7 years.
Thank you.
All right, thank you for that clarification, Nadine. We're moving on to a question from, this is Arthur, asking if I'm a licensed esthetician in the USA, can I open my own business and sponsor myself? Can I then apply for residency to remain in the USA?
Let me make sure. Okay, no. There is a visa category in the United States where they say that they welcome persons to open business in the United States, and they can get a visa in that way. That visa category requires that you generate employment for a specific number of persons. I think it is maybe 10 or 20 persons, and they actually tell you how much money they expect that you are going to be infusing, as it were, into the US economy. So if you go on the website, uscis.gov, and you look, you can see, for example, they may say you have to be able to generate $100,000, 100,000 US dollars, or 50,000 US dollars, and you have to employ this minimum number of persons. So there is such a visa category, but you have to bear in mind that it requires a significant economic outlay on your part. And of course, if you come with your $100,000 and you don't employ the particular number of persons that they expect that you would have employed and that you agreed that you would have employed, there can be repercussions.
All right, thank you. So we have just about 5 more questions and then we can wrap up. Omari asks, what paths the citizenship exists for international students, meaning students doing bachelor's, master's, doctoral degrees in the USA?
There are no paths. If you are an international student, you come to the United States on what is called a student visa. And at the end of that, you are lawfully expected to return to your country. There are persons, as we well know, because we know this is the real world, who do not return, and they have to seek other methods. But if you are an international student, at the end of your bachelor's, master's, whatever it is, you're expected to return to your country. And I'll say this, there are some countries that, I think in Jamaica they call it that they bond you. There are some countries that require that you come back and work for 2 years or whatever amount of time. And if you don't, you might have to pay back that money that your home country spent on you. Let's say you were working in the government And when I mentioned the government, because there have been scenarios where persons were sent by their countries to the United States to study, and they expected them to come back, and they did not. And when the government was asked to sign off on some certificates for them, the government refused to do it because the government said you've actually broken your contract that you had with the government. But let's say regular Nadine Flowers went to the University of wherever as an international student. When I'm finished with my degree, I would be expected to return home. And if I don't return home, I am out of status and I can be deported.
All right, that one is a little frightening. We're moving on to Keon. If you're not the principal applicant on a petition, let's say you are unmarried, you are an unmarried adult for the parent being petitioned for, is that still updated on the consulate system?
I'm sorry, can you repeat that?
All right, Ken, I think if you open your mic and ask the questions, because I'm not sure I follow what the question is asking.
Oh, I think somebody's speaking, but I'm not hearing clearly.
The connection is a little bad. Can you just go again, please? All right, we're not hearing Keon, so we can just come back to her.
Sure, or maybe she could type it again.
Type it again, right. But let's move on in the interim.
Or, sorry, I've got my email address up there. Perhaps she can just send me the question and I could try and answer it since we're not hearing.
Okay, awesome. All right, so Therese Riley asked, is it possible for a child that has aged out who was being petitioned for to still get that visa?
Yes, that child, despite the fact of him or her aging out, can get the visa. There is a process that the government uses to freeze your age. So let's say, for example, the documents came in, you're waiting, and you're 25, and you've been waiting for 5 years. The government has a mathematical formula that they use. In real terms, you will be considered as 20 because you're now 25 and it took 5 years for your documents to get to the front of the line, for your priority date to be reached. So you would still be considered under 21 in the law. However, if you are 25, excuse me, if it took 1 year for your documents to get to the head of the line, you would now be 24, and therefore you have aged out and you have to go into the other category. You are no longer a child. You are now going to be considered an unmarried son or an unmarried daughter. It's a little confusing, but even if you have aged out, you can still be petitioned for. It's not an issue at all. It is just how long it will take. That's all that it is.
All right, thank you. So I'm seeing a question here from Kiadi Brown. Hope I pronounced it right. The question is asking, if my dad is a US citizen from before I was born, and I was born in Jamaica in wedlock, do I qualify for automatic citizenship as a foreign-born child if I am now over 18 years old?
That is something I would have to do some research on, because I do know that there is a provision for children of US citizens who were born abroad to parents in wedlock. But I couldn't tell you about the specifics of your situation. That is something I would definitely have to research. But I know that the law, the American law, does make provision for children born overseas to US citizens to become citizens. So that's about all I could say. But for the specific case, because it sounds like a very specific case, that's something I would have to do some more research on.
Great. So Kiadi, what you can do is to take Mrs. Flowers' information and just send her an email for a follow-up to that question. All right, so Donette asked, does a divorced person fall under the category unmarried son or daughter over 21?
Does a divorced person fall in the category of unmarried son or daughter? You know, I've never actually had that issue. That's an interesting question. One thing I'll answer it this way. Having never had this question myself or had to think about it, there's a place on the form that asks you for your status. So you would have to put that you are divorced on the form and see where it goes from there. But that's definitely not one that I have met in my practice. But I would caution you that when you're filling out the form, if it is you or whoever it is you're asking a question for, on the form, make sure to put that you are divorced, because that may well be very important.
All right, and just to go to our last question of the evening, Kim Ray asks, how long does it take for a spouse visa to come through? I know you said it's based on the situation, but if there's a general timeline.
Right. I'm going to say, based on the fact that over the last 4 years, there's been a slowdown, a deliberate lengthening of the process by the government. There is a huge backlog now. So I think for the visas as it relates to spouses, you're perhaps looking at maybe anywhere from 6 months to a year. I would say is a very generous time frame and way of looking at it. And that is on the premise that they are not asking you for additional documents, on the premise that everything you have submitted is fine and you just go and do your interview and collect your immigrant visa. So I would say anywhere from 6 months to a year.
Okay, great. So as always, Nadine, thank you so much for providing a lot of knowledge. I found it informative. I found information so useful, and a lot of the myths have been cleared up, and we're moving in line with all the facts and know how to do the right things. So participants, thank you so much for joining the session. If you have additional questions, her email address is on the screen. Her website is also on the screen, so you can definitely contact her from that information. Should you need to access the recording just to go over what you might have said, you can email my email. I'll put it in the chat shortly, and then you can just send me an email asking for access to the recording. So
can I just say, this is a good rule of thumb for generally anything, but specifically for these kinds of forms. Always err on the side of caution and tell the truth. Don't assume, them not know. Them to know that. Assume that they know. And if you're confused or you're not sure, you try and seek clarification. But always err on the side of they most likely know and answer the questions accordingly. You don't want a simple little white lie or a little mistake to mess up your documentation and your benefit that you could get. And if you go to the embassy, for example, and they ask you a question, and you see them look at you and them take off them glasses, or they start typing on their computers, red flag, you must know, obviously they know about that. Just think about that. It's always better to just come with clean hands, as we say, and act accordingly. It might take a while, but you will get the benefit at the end of the day.
Okay, great. So rule of thumb, be honest at all times. All right, so thank you again for presenting, Nadine, and thank you participants for joining. You can just look out for other emails of upcoming webinars, and we'll see you and chat with you in the future. Good night.
Take care, everybody. Bye-bye.
Bye.